Hi everyone, welcome to the webinar. This is Attorney Ben Sowards here to talk to you about 3 simple steps to protect your family and your estate. We're going to go pretty quick today. We've got a lot to cover. We give workshops like this at least once a month at the community center in Campbell, California, which is right near San Jose. We also have, for your convenience, we have online webinars, and then we have some recordings that you guys can certainly view. If you see anything in this webinar that you'd like to know a little bit more about, please feel free to log on to our website at sowardslawfirm.com. You can also call the office at 408-371-6000 or send us an email at info@sowardslawfirm.com. All of our contact information will be available for you at the end of the presentation as well. So a little bit about me. I'm from San Jose. I attended San Jose State University. I also went to law school at UC Davis. I've been married 18 years and I have 4 wonderful kids. For fun, I like to ride my bike. I like to go surfing. I also help coach sports, and I've been a Cub Scout leader in the past, and I've been an attorney now for 12 years. This is my team at the Sowards Law Firm, a California estate planning law firm. You can see us all there. This is the group that you'll come work with when you come to our office in Campbell or any of our satellite offices, and we are the ones who are going to be helping to protect your family. These are some of our awards and recognition through the years. Lots of awards through Super Lawyers or AARP. Anyway, we've been selected for quite a few honors, and we're proud of that. So let's just jump right into it. So typical goals when most people come to see me, here's what they express. They want to stay in control, they don't want to become a burden to their loved ones, and they want to keep it simple. And now usually keep it simple means let's keep the price down. We've got all types of plans here at the Sowards Law Firm. We have so many options for your family. Anyone who's over 18 should have some sort of plan in place for their financial affairs and also for their health care. We can help you out with those. We work with clients with, let's say a modest net worth of $100,000 or so, and then or less. And we've got clients with tens of millions of dollars. So whatever your need, we can find the right group at our firm to work with you. So why don't people plan? Well, number one, they think it's expensive. They think they don't own enough. They think they're not old enough, or it's confusing. Some of those are true, and some I think they're myths. It's expensive. I guess that just depends. Not doing a plan is much more expensive than sitting down with an attorney and preparing your plan. In fact, I find on average that people who have a plan will pay, 90% less than if somebody had gone through probate. Okay, if you don't think you have enough. So in California, the rules are, if you own a home or if your net worth is over $150,000. You should most likely do a plan. In fact, you should probably do what we call a revocable living trust. That's a legal contract to manage all of your assets and your person if something happens, if you become disabled, or if you die. And so you're not old enough, like I said before. Anyone over age 18 should have something in place, even a basic plan such as a power of attorney and healthcare directives. And then if your net worth is high, more, we'll talk to you about some other types of estate planning. It's confusing. It can be. So hopefully you'll sit down. You should have a team of advisors that you work with. Of course, you should have your attorney. You should have a CPA, and I think you should have a financial advisor. That is your group that will help you plan for your family, and that's a group that's going to be looking out for your family long term if something happens to you. So I believe there's 3 steps to protect your family and your stuff. First off, you need to know the rules. You need to know the risks. Those are creditors and predators. And then you need to know your options. Okay, what can you do about it once you know what's going on and you understand the risks? Okay, so know the rules. Here's a kid talking to his dad. A raise in my allowance is fine, Dad, but what I'm really after is the power of attorney. Nice little attorney joke there, but it's true. Power of attorney gives a lot of authority, a lot of power, much more authority than just having someone's cash. So what are the rules? While you're alive and healthy, meaning that you have mental capacity, you get to manage all your own stuff, just like you're doing today. You have your bank accounts, you have real estate, and you're in charge of all of that. Nobody can take that over from you without your permission. Now, but what happens if you lose capacity? Who will make your legal and financial decisions? If you lose capacity, meaning that maybe you are in a coma, or maybe you've got severe dementia or Alzheimer's, who would make your healthcare decisions? And when you die, what will happen to your stuff and to your family? Have you left clear instructions? That's what's important. We're going to help you so that you do leave clear instructions for your family members. So there's two sets of rules. During your life, who has authority and when do they get control? And then after death. So when you're alive, you need a power of attorney. That gives somebody else authority to manage bank accounts, to work with Social Security, to manage all sorts of legal and financial affairs. You also should consider an advance healthcare directive. That's the document where you might say, okay, my wife or my husband and then my father can manage my medical decisions if I can't. And then in there you can say, what do you want to happen? Do you, if you are, have no chance of recovery and you're terminal, would you want your loved ones to pull the plug? Or would you want every life-saving treatment possible? You know, so you would want your family to work with your doctor to make these decisions, but it's terrific if you have a say in it. If you say, no, if you know, the burdens of this surgery, I might not make it anyway. You know, I'm 90 years old, I've got cancer, and now they want to do some sort of advanced surgery. No thanks, I don't want it, I've put it in a document. Okay, so then after death, what happens? If you own real estate or your net worth is over $150,000, in California, you end up in probate court. Also in California, it really doesn't matter if you have a will or you don't have a will. That means if you die intestate, that means you died without a will. You end up in probate court if you have real estate or your net worth is over $150,000. Well, why? Because only a judge can take assets out of your name after you die. And so we'll help you to figure out, well, how can I make those, how can I take the assets out of my name but still manage them while I'm alive? So a durable power of attorney, that is a document that allows for an agent to manage all of your legal and financial affairs. Those are especially important for if something was to happen to you and you need a family member to manage your pension or your Social Security or your 401k. That's typically done by a durable power of attorney. Okay. Healthcare directives, we talked a little bit about it, but you can say who can help make decisions for you and when. Some clients choose to give over control right away. That's rare, but you know, I've had some elderly clients where their kids are already managing everything for them. They're doing it without legal authority, and so we might have them sign on and put their kids on immediately, either managing finances or healthcare, and then you can decide which type of information they have. It's perfect if you can give a clear statement of your intent to your loved ones. There are check the box forms that we can help you out with, but you also have the opportunity to write in you know, some of your own wishes. We call that a personal care plan, where you might say, hey, here's how often I want to see these certain family members, or I like to go out to eat this often, or take me outside every day. Things like that, so that if you couldn't speak, at least someone would be honoring your wishes. Okay, documents versus planning. Sometimes people come to the office and they say, well, my friend got a will or my friend got a trust and that's what I want. Well, you know, there's lots of places that sell documents. They're all available online, but people call us, gosh, every week and they say, I did this thing online. Can I pay you to come review it? Well, why? Because they got a good price usually, although usually not good value. They paid a low price by going online, but they don't have peace of mind. They're not sure they got the right documents. And so then they're taking it to their financial advisor, they're taking it to their CPA, they're taking it to their attorney, or they're trying to find an attorney to see if the plan will work. We do that for people. We bill them by the hour. Usually it's cheaper to just work with us or some other qualified estate planning attorney and get the right document in place from the start. But anyway, we will help you find the right documents for your family. We're here to give you peace of mind. We just want to make sure that you know what you've purchased, that you understand it, and that you're happy with it. And then things change over time. So if your decisions or your assets or your family dynamics change over time, we want to make sure we're updating that. I find that people that kind of pull like some do-it-yourself software, they do it once and then they throw this plan in a drawer and then nobody knows about it. It's almost useless. So documents versus planning. We say that we're estate planners. You know, part of what we do is we will provide you with the correct documents that are relevant for your family, but more importantly, we're going to sit down with you. Most of our time is going to be spent finding out what your hopes are, what are your desires, what are your fears, what are you trying to protect, what's important to you, and then we're going to design that plan. Now, part of the plan will be putting in place wills or revocable living trusts or durable powers of attorney, healthcare directives, personal care plans, memorial instructions, and many other documents. But what's most important is the plan, okay? And why do kids fight? You know, the purpose of this slide is that often we see, you know, family law attorneys, they deal with spouses who are separating and fighting and going to court and all that. Estate planners, we frequently deal with siblings that are fighting, and they're fighting over, not to say people are greedy or they're fighting over money, or and sometimes they are fighting over money, but usually they're fighting over control. They're not quite sure what mom wanted. She did not leave a clear plan, and so the kids are guessing. Well, mom told me she didn't want to go into long-term care. She wanted to pull the plug. Well, no, she told me last week that she did want life support and would go into long-term care. And then quickly the fees escalate. Siblings or kids end up in court fighting over, they're both trying to protect their mom, but now they're wasting a lot of time and money and causing a lot of family strife that didn't need to happen. We find that good plans, we sit down with you and we're going to design the plan, and then if possible, we'll have a family meeting. We'll help your kids or your parents or your siblings to understand what you've requested and what we've drawn up for you, and those plans work. We also have plans that are kept confidential. People don't want anything disclosed until they die, and that's very common, and that's also fine. And those plans work as well as long as they were set up the right way. Okay, number two, you need to know the risks. Okay, what are the risks that we're facing and that we're trying to address? And so this is, you see a guy floating over his body and says, next, I remember looking down at my body and my kids fighting over the will. We've seen a lot of families that get torn apart through ending up in court. Our goal, you know, we practice estate planning. We also go to court. We represent trustees. We represent kids who want to challenge a will that maybe wasn't done the right way or with undue influence. But at the end of the day, we understand that these are family members and we're trying to repair family relationships. The worst thing that can happen is your family to all be torn apart and then all the money to go out to attorneys. You know, the attorneys will be paid for what they do, but you should be working with an attorney that has a collaborative approach that is looking to settle things rather than fight, and really run up the bill. Okay, so you need to know the risks, and so those are your predators and creditors. I consider predators and creditors to include government, long-term care costs, that would be like nursing home, your family, such as your husband's new family, and lawsuits. So we want to try to protect against all of those things. So this is your son-in-law, Fred. We would hate it. One of the risks is that you would lose your hard-earned assets to creditors or predators. So Fred hasn't had a job since 2006. He belongs to a religion that you consider a cult. You suspect he's fond of chemical substances, and he thinks it's great that he has rich in-laws. Is he going to get half of what you leave to your daughter? Well, I hope not, but it happens all the time. I can help you protect that so that doesn't happen. Also, here's Elaine. You know, are you going to lose your hard-earned assets to your spouse's next spouse, Elaine? So this is your husband's next wife. In the month since your death, she's brought over home-cooked meals to your husband 6 times. Each time she visits, she wears a skimpier outfit. She can't wait to redecorate your home, especially that hideous wallpaper you chose. She also thinks there's no good reason that the money earmarked for your children shouldn't be spent on more important things like jewelry, sports cars, and European spa vacations. That sounds nice. I'd like one of those. Is she going to get half of your children's inheritance, or maybe all? Gosh, I hope not. So those are some of the predators that we can, you know, we should be thinking about and we should be planning around. You know, often when a couple or a family comes to meet with me, they might have a certain thing. Maybe they want a very straightforward, simple plan, and we often start out that way. And then as the couple matures or gets a little older and their net worth goes up, frequently we change the plan and we might make it more restrictive. Often people will start with a plan where we say whoever lives longer has full control. But then as they start to get more money, they say, well, wait a minute. I think that if my husband outlives me, he can control his half, but not my side. And so we can do that. So you also have some unanticipated predators. So, you know, like your child with drug or alcohol problems, your child with a disability, maybe on Social Security or on Medi-Cal, and then also lawsuits against you, your spouse, or your kids. We can design a plan where we can protect around those things. Now, not every plan does, and certainly you have to select the plan that does that, and there's always a give and take. If we make things more restrictive, then there's more protection for the kids, but maybe they have to call a trustee or their uncle or somebody or their aunt to help manage things. The easiest thing to do is just give everything outright, but then there's no protection against a divorcing spouse, a kid who goes through a divorce, or a lawsuit or anything like that. So the government can also be considered a predator in the probate context. So what's probate? Probate is a court proceeding where we're working to get somebody's assets, somebody who's died, trying to get their assets out of their name. And so if you have bank accounts or real estate or anything where you're the one on title and then you pass away, if you don't have a plan, or even if you just have something simple like a will and the assets are in your name, your family is going to have to go to probate court. It's a public proceeding. And only a judge can deed the assets out of your spouse's name and then into your name or into the kid's name. Now, I happen to do most of my practices in Santa Clara County, which is, I think, the busiest and the best probate court in all of the state. We have an excellent judge, tremendous court staff there, but they're busy. They are the busiest probate court in the whole state, and so probate can often take 2 years to get through. Throughout California, but especially in Santa Clara County. Probate is public, and so any one of us can go sit in the audience almost any day down in probate court. In San Jose, it's 191 North 1st Street, and you can go see what's going on. You can find out who was put into a will, who was cut out, who's challenging something, how much money did they have. It gets pretty juicy. Well, guess who also finds out? Maybe people trying to sell timeshares, people trying to sell cars. A sports car is the number one thing that people go out and buy when they get their money when a probate closes. Now, if there's enough money and that was part of your plan and you wanted your kids to go buy sports cars, well, terrific, let them. But often that is not what clients want, and so they want a plan where that's not allowed. Okay, so anyway, probate court is public. It's also expensive. If you take a very average estate in Silicon Valley, where I practice, a home is easily worth $1 million or more. Home might be worth $2 million. And then they have all these other assets that would also go through probate, bank accounts, brokerage accounts, things like that. Well, those accounts, all of that ends up going through probate, and the fees on a very average $1 million estate, the fees are $46,000 to attorneys and executors. That's money that could easily go to your family. There's no need to go through 2 years of probate court and then to pay out a lawyer $46,000. You could have done proper planning and just kept almost all the money in your family. Also, whenever we go to court, people who might have left something alone, once they know, hey, I might get my day in court, probate invites fights and will contests by family members or people who are disgruntled who think, hey, I should have been included all along, or so you're just opening the door for a fight and higher attorney fees. Okay, so the cost of probate in California, email me if you'd like to get this schedule. I have this fee schedule that I can share with you, but the fees range. You're in probate court if your net worth is $150,000 or more, and the fees start at $11,000, and they go up very quickly. You can see how easy it is for attorneys and others to quickly have a very good year depending on the size of your estate when you die. You take $5 million estate, the fees are at least $126,000. So no need to do that. Keep more of your money with your family. Call me and I'll share that with you. You can call us at 408-371-6000. You can also email us at info@sowardslawfirm.com to get this fee schedule. Okay, so what's a conservatorship? A conservatorship, this is for people, I talked a little bit earlier about a durable power of attorney or an advanced healthcare directive. This is for people who never put those in place, and now they're disabled and they don't have the ability to make legal decisions. Well, at that point, it's too late. You can't have them sign a durable power of attorney. At that point, you have to take them to the probate court, and it's a special type of hearing called a conservatorship where a judge decides if you're incapacitated, and a judge will decide who will get to manage your affairs. You should be deciding those things. If you want your spouse, it should be your spouse. If you want your kids, then name your kids. You don't want the court deciding, hey, the public guardian's going to manage your stuff, and you're going to pay them a big fee every year to do that. Okay, so we want to make sure we avoid that as well. Okay, another big risk is people who fail to appoint guardians. If I see a younger couple come into my office, usually this is what they're here for. They want to make sure, they've heard about probate. They're kind of worried about the fees, but they want to make sure they've put in a guardian for their kids, or they put in one person 5 years ago, and now they've had a falling out with that person, or they don't, the person moved away, so it's not a good fit. Don't let the court choose your kids' next parents. You should be selecting that, and you need enough alternates. You need to give me with several names. We have something special in our office where we have a guardianship panel. If you can't decide, often people will delay. They're not sure. They delay planning because they just can't decide. Well, I want my sister, and you want your brother, and we just fight over it. Well, what we can do is we can put in place a guardianship panel where we'll just choose three people who are important to you that you trust, and we'll kind of kicking the can down the road, and we'll say we'll appoint guardians. These 3 people will select the guardian after we're gone. That's one option for people who can't decide. Otherwise, you just give me a list of names. You will put in who you want first. If they can't do it, we'll go down the line to the next person. And I've got lots of international clients. Being in the Silicon Valley, the Bay Area, lots of our clients are from overseas, and they want their family back home, in Europe, in India, in China, to be the guardians for their kids, but it would take their family a week or 2 to get here. Well, I never want your kids to go to foster care or child protective services. So what I'll do is I'll also have you appoint a temporary guardian. And this would be somebody who you let the kids go over to their house. They would be, they would, apologize for that. That's one of my meeting. But these are people that you would let pick up your kids from school. These are family friends who live close by who could watch your kids for a week or 2 until the real guardians get here. It's important that you leave babysitter instructions. This is your chance to say, gosh, if I was gone, if I have 4 kids, so if we're hiring a babysitter, we often have to, if it's a new sitter, we either have to give them handwritten instructions, or we need to, spend 20 minutes relaying to them, all right, what are the rules? What are they allowed to do? How much screen time? You should be doing something similar for your guardians for your kids. If you were to pass away, they need to know what's important to you so they can follow your wishes. Furthermore, we have clients where they might choose, international clients, they might choose someone here in the U.S. to be the guardian, but then that will write into their plan that the kids go home once a year to go see family overseas. That can be in there, and your estate can pay for it. So another risk to consider is the estate tax. Currently, we have the highest estate tax exemption that we've ever had in the history of our country. Right now, there's different tax treatment for U.S. citizens versus non-citizens. Non-citizens kind of get the short end of the stick. They get the worst tax treatment. So if you're not a U.S. citizen, then come see me and I'll explain some options for you. Luckily, there are ways around it so that you can get the same tax treatment as U.S. citizens. You just have to do more planning in the beginning to get it set up. So if for U.S. citizens, there's no tax on the first death, okay? So Steve Jobs passed away a couple years ago. He had billions of dollars left to his wife and other family members. He had a trust, so it's mostly private. We don't really know where things went, but versus a will, probate court, that's all public. But when you have a trust, you can keep things private. But there was no taxes due on the first death. It'll be after his wife passes that there, probably be a large tax bill. It's pretty easy for us right now. You can protect almost $5.5 million from any estate tax. And those are the 2017 numbers. And that includes everything you own, even foreign assets. And so it's important that when you sit down to plan, you disclose everything to your attorney so that they know about all of your assets worldwide and also your insurance. People frequently don't take into account, hey, I've got $2 million in insurance, but my net worth is $4 million, so I don't have an estate tax problem. Well, yes, you do. Sometimes you'll hear that life insurance is not taxable. That's true. It's not taxable from an employment standpoint. So your your beneficiaries, they don't pay income taxes on it, but they do pay estate taxes if your net worth is over this 5.49 number. So it's something to watch out for. But with estate planning, we can double that amount. So we can almost get you $11 million if you're married, exempt from any estate taxes. So that covers, 99% of the U.S. population, but if your net worth is over that, then we have some advanced planning we'll talk to you about. We're not going to address that here today, but there are options for your family. Okay, so step number 3, part of the 3 simple steps, is you need to know your options and plan. Legal advice 5 cents, accurate legal advice $5,000. Everybody's got an opinion, everybody's heard this, or they've watched the People's Court. Hey, those shows are fun, but usually what they're doing there is not actual legal advice, doesn't apply. And so you want to be careful. It's free advice or 5-cent advice. It's worth what you paid for it. So what are some of the common types of estate planning techniques? Well, you know what most people do? They do nothing. And then if you do nothing, you get the California probate code, or whatever state where you live when you die, that you're going to get their probate code. And that's the government rule book. The probate code says where your stuff goes and when, and generally speaking, you lose the ability to plan. You lose the ability to make any tax planning. You lose the ability to hold assets in trust, managed by a family member for your kids. Everything just goes to your kids outright at age 18. And I don't know about you, but I know that I was not responsible enough to manage a whole lot of money at age 18. And so most people aren't. And so what we do with our clients is typically we choose some ages. The money's always there for your kids. They just have to be checking in with a trusted family member to get the money. Your kids say, hey, I got into Stanford and I need to commute, up Highway 101. And I want a Mercedes. Well, you know what? Depending on your family situation, that could be a possibility, but most families might say, you know what? Yeah, you do need a car, but you get a Honda. You get something reasonable. We're not going to let you go and blow all the money while you're young on these depreciating assets. The trustee or the money manager's job for your kids is to help protect the money and help them make good decisions. Another way that people own property or plan is they do joint ownership, or they do joint tenancy. Joint tenancy will avoid probate on the first death, but you'll get a probate on the second death. And then furthermore, you won't get a chance to help plan the estate. If you own assets in joint tenancy, it just goes to whoever lives longer, and then it goes through probate, but they can do whatever they want with the assets rather than you having any input or say. Sometimes people own assets with their kids, which I don't really, I don't like it, and here's why. If you own an asset with your daughter and now she goes through a divorce, guess what? Her spouse is going to say that, hey, that's part of our marital property, and we commingled that. That's all part of the estate. Why spend money fighting over that? Or what if your daughter gave it away, and she could, or her share at least? Or what if now your daughter or your son, you own assets with your son, and your son has an accident on Highway 85. Guess what? In that lawsuit, they're going to find out about that home that you co-own with your son, and they're going to be trying to collect on that. So even if you have a child who doesn't have much money, but you put him on title to one of your bank accounts, or you put him on title with you to your home, you have the risk of losing that. People often will give away assets during their lifetime. They think, I'm going to be smart about this. I'm going to give something away. There's all kinds of consequences with that if you do that. I don't love it. You should give things away at your death, generally speaking. When we give something away at our death, we get a step up in basis. And so with that, you pay taxes on the gain. The difference between what you bought it for and what you sold it for, that's usually taxable gain, and sometimes there's some exemptions. But if you give something away at your death, the basis is usually reset to your date of death value. Your kids get those assets, and if they sell them, they can often do it tax-free. So I don't love giving things away. Also, your kids could then give it away or lose it. Some people do beneficiary transfers. That's okay. That's not bad. I like those, especially when it can keep you out of probate court. But if you're giving something to your kid and they just get it outright, all the same risks apply. A better approach, I think, is you might name your 401k and your IRA, you might name a trust to manage those assets for your kids. And then if you've designed a pretty nice plan where the trust is holding all the assets until your kids reach 35 or 40, then all of those assets can be protected from lawsuits or just foolish decisions while they're younger. Some people have wills. A will, that's the standard. It's always in the movie where you see people sitting around the conference room table and the lawyers reading out, all right, you're getting this and you're cut out and you're disinherited. And it's always kind of juicy. It makes for good television, but it's usually not great in California for all the reasons we discussed before. But often people will write up a will and then they'll throw it in their filing cabinet or their drawer and they won't look at it again for 30 years. You're planning your estate, you should be proactively involved. I ask my clients to look at their plan, whatever type of plan we did. Look at it every April 15th. Do it on tax day because that's a day we all dread anyway. So, and it's always on your mind, so you might as well add something to it. Take a look at your estate plan and just see, is this still in great shape or do I need to call the lawyer because something happened? We will reach out to you with changes in the law or things that I think are relevant to you. I need you to reach out to me if you have a new child or, maybe one of your kids, we need to restrict their share or, we had it going outright at age 25, but now it needs to be 40 or, it's your plan, so you get to choose. Okay, other types of plans include revocable living trusts. That's your family rule book. That's a document you sign and you set forth whatever you want for your family, within reason. And if you're married, then it's a contract with your spouse and you say, here's what happens when one of us goes. We agree that here's how all of our assets will be managed, just giving you peace of mind. We also have something called irrevocable trusts. Those are trusts where you might be giving something away now so that you can get asset protection, or if a client is looking to get on Medi-Cal, and that would be where maybe they are going to go into a nursing home and it makes sense to have them apply to get some state benefits, then often we're going to be working with them on an irrevocable trust. Okay, so estate planning is a lifetime process where I control my property while I'm alive. I take care of me and my loved ones if I become disabled, and I give what I have to whom I want, the way I want, when I want, all for the lowest possible costs and fees. So we do that typically in my office. Most of what we do is revocable living trusts. We also provide wills, powers of attorney, and healthcare directives. A will, we've talked a little bit about it, but it's a formal document. It does not take effect until you die, so it's essentially useless until you're gone, and it transfers what you own at your death, and it does not affect jointly owned property. So if you own title and joint tenancy, you own your home in joint tenancy with somebody, and then you say, I'm going to go write up a will and give my home to somebody else, that will not be valid. Title controls, okay? So the deed that says joint tenancy controls. Or if you said in the past you had all these beneficiary designations on life insurance or IRAs or 401ks, and then you say, well, no, I'm going to write up a will, I'm going to leave everything to my wife, and before all of my accounts were going to my brother or something like that, well, guess what? Beneficiary forms trump wills, and so your will would be useless, and you might end up cutting family members out. So it's more important that you would meet with an attorney and design a comprehensive plan where you sit down and you say, where do you want everything to go? And then you figure out which accounts are going to be managed by those documents. So a complete estate plan should include a thorough analysis of your family and your assets. Every family is unique. Should include durable powers of attorney, healthcare directives. If your net worth is over 150 or you own real estate, then I'm going to recommend a trust. If it's below that, you might just be okay with a will. But then you'll add on some documents like a power of attorney and healthcare directives. We'll have personal instructions to your family, and we'll have personal instructions for your care, things that you want. And then you should be working with a knowledgeable estate planning attorney, CPA, and financial advisor. That's the trifecta there. So how do we protect our stuff? We do it with living trusts. And I think of the living trust as your family rule book. Rather than relying on the probate code, you will sit down with someone in our office, myself or another lawyer, and we are going to help figure out what you want. We're going to design a special type of contract or plan for your family that's going to control your property during your life and after your death. Now, a trust has three important parties, and they're all you. There's the settler, there's settlers, that's who sets it up. There's the trustee, now think of that like the manager, and then there's the beneficiary. You're the beneficiary while you're alive, and then after you're gone, it's often your kids or other family members or charities. It operates, unlike a will, it operates during your life and after your death. As soon as you sign it, and we put something in it, usually personal property and then your home, and then we'll tell you how to get all of your bank accounts in there, then that trust is fully funded and it controls all of your property. So if you are traveling and you have an accident, everything's owned by the trust, and somebody else can manage it for you, your trustee, your next trustee in line, maybe your spouse or a child. Or if you pass away, then that person's job is to pass out the assets the way you directed. Okay, so your living trust or your family rule book, it says what is going to happen to you while you're incapacitated and after you die. It absolutely avoids probate. We design our trust with something called a pour-over will. And so what that means is if you left something out of your trust, so when you set up your trust, you change title out of your name, and now your home is owned by your trust. Now you can cancel the trust at any time, and you're the manager of your trust. It's like a big company changing out CEOs. A trustee can be changed out over time. But your successor trustee can control your assets and manage your accounts during incapacity or death. And then you're in control because you've set forth the guidelines. You say how things go. We'll help you with what's required legally, and then you can help us with what you want, what's unique or specific to your family, and we'll make sure that all goes into your family rule book. Then you won't need to go to court. You won't need to go to go see a judge. Everything can just be done in the privacy of your attorney's office. Now, if somebody leaves something out, let me get back to my point. If somebody leaves something out of their trust, we can use a pour-over will to get it back in. I call it our get-out-of-jail-free card. So what that does is if you, here's what happens is people refinance their home, and then banks are sometimes, they don't put the homes back into the trust, and then you pass away. Well, then we would go to court, and it's not a probate, but we would just say to the judge, look, judge, so-and-so had a trust, and he had a pour-over will, and the will says give everything to my trust. And we'll get a court order. It'll cost a couple $1,000s, but it's nothing like a probate, where you have tens or hundreds of thousands of dollars. So what can be held in a trust? Almost any property, homes, ranches. You could put personal property, bank accounts, brokerage accounts, businesses, all types of things can be held in your trust. We usually are not putting IRAs, or we never put those into the trust, but you can make the trust the beneficiary of an IRA or a 401k or life insurance. That way, if you've designed a plan where you say, hey, my money is going to be managed for my kids until they reach, and the trustee will be managing it until they reach age 25 and they get a third, and then 30 they get a third, and then 35 they get the rest. You're making sure that everything's managed for them rather than them just getting it at age 18. You're helping them to be responsible. With a trust, you can also protect your money or your estate from the new spouse, Elaine, that we heard about earlier. If you want, you can divide assets between different buckets when one person dies. That's how we were earlier talking about doubling our estate tax exemption, but it locks up money for the benefit of the family. And so if your husband or wife gets a new spouse, your husband or wife can change their half of the money, but they can't change your half if you're the one that's gone. They can still manage it and use the money, but they're not allowed to then add their new spouse to what was your share of the money. They have their share where they can make changes, but not on your side. You can also protect the inheritance that you're leaving your family members from creditors and predators. If you leave money in trust for your children, and then you appoint somebody else besides them, like an uncle or a family member, to manage it for them, you are giving them asset protection. And so if your child is sued, they have that accident, or they go through a divorce, they're not in control of the money. They always have to be checking in with somebody, and that other trustee cannot be forced to pay out, as long as the trust is set up the correct way. If you have a plan where everything just goes outright to your kids at any age, 18 or 25 or or whatever age, if it just goes outright, then as soon as they get it, they could lose it in a divorce or in a lawsuit. And so some of my clients, they do choose lifetime trusts where they just say, this money is managed by my brother, the kid's uncle or aunt until a certain age, and then I'll allow my child to become a co-trustee at age 30, and then at age 40, if you pick the ages, they can remove their aunt, but they have to appoint someone else to manage their assets for them, with them, I should say. That way, if there is a lawsuit, there is a co-trustee, there's somebody else giving them protection, and the co-trustee can't be ordered to pay out. And so that's a nice way to get lifetime asset protection for our family. You can also do a distribution trustee. Sometimes people want to have their kids manage the money, but they have to check in with a third party to take anything out, and that's another way to build in creditor protection. Okay. So you're going to decide what type of plan your family needs. Plans can be simple or they can be a lot more advanced. Some plans are just everything to my spouse and then everything goes outright to my kids. Well, we have those plans and they're great plans. They will avoid probate, but they're not going to have creditor or predator protection. But if that's not a concern for you, well then we're just going to give you what you need. I'm not here to lawyer something or to upsell you something when you don't need it. We're going to find out what are your concerns and we will help you get that plan. I have lots of clients come to my office. They have certain concerns. We'll give them the plan to put their mind at ease. And if you say to me, well, Ben, I'm not concerned about holding the money beyond, age, 18 or 21 or 25. Well, fine. We'll help you with that plan. Plans can also be advanced. We'll find out what you need and we'll prepare that plan and we can design a plan that has additional creditor or predator protection so that if you have a child, and the plans can be different. If you have one child who's 40 and is responsible and doing great and you just want that person to get her money outright, you can. But then you've got a younger child who's not doing very well and you think there's some concerns about who they're dating or lifestyle choices, drugs or alcohol, you could say their money's held in trust for life and always managed by somebody, their sister or somebody else. Or you can say it's held in trust till they're 50. You get to decide. As long as it's legal, we'll help you prepare it. We talked a little bit about this before. Irrevocable trust, a way of getting asset protection. It's often used by folks who would like to who may need to go on to Medi-Cal or some sort of nursing program, skilled nursing facility. It's also a way that you can get asset protection for yourself. We have trusts where you can give something away and whatever you give away is protected and then whatever you keep is, may not be protected. So sometimes people might they'll take a rental property and stick it into an irrevocable trust. And then if anything goes wrong with the tenants at the rental property, the tenant can only collect in a lawsuit on what you can collect. So if you are entitled to income and principal, well then the tenant could get that. But if you're only entitled to income, then in a lawsuit a tenant could only get the income and they could never invade the principal. So we have different approaches. We have some we'll be putting up some more advanced workshops discussing that if you want to hear more about it, or always call me at 408-371-6000. So once your plan's done, I touched on this earlier, but you do need to maintain it. Once you create your rule book, your family plan, are you all set? Well, that depends. Things change, your family changes, your finances, your health, and sometimes the law changes. I can reach out to you with changes in the law, but I need you to call me or email me with changes to your family, your finances, or your health. And then some options for maintaining your plan would be you could do nothing. You put it on the shelf and then call me when somebody dies. That's one option. I don't love that. There's also, self-maintenance. Just look at your plan every April 15th, or you pick the day, end of the year, and just call me if something comes up, and we can update it. Then we also have an annual maintenance plan in our office, and that's a great way to make sure your plan stays up to date during your life. Free phone calls with the lawyers, and you're not afraid to call in and ask a question. And then if, often people call in and they'll tell me what's going on with their family, and I'll say, well, your plan's in great shape. We don't need to change anything. There's no new work needed. And then other times, yes, we do need to update things. You should plan to update your plan about every 10 years. Or more frequently if there's changes, big changes in the law, but about every 10 years is it's worth an update. Okay, so with proper estate planning, you can decide who inherits your assets, You can control how your beneficiaries inherit. You can plan for care in the case of disability, and also you can also manage your financial assets during disability or upon death, and you can eliminate estate tax. So call my office for a face-to-face meeting to choose the plan that's right for you, and we'll help you set that up. I see I got a typo there, but that's it. Now, if you have questions about this, please call or email me to discuss. We give live workshops. We have some scheduled. I don't know that we have any scheduled for 2017 yet, but we will be giving some live workshops in Campbell if you want to come to one of those. We'll also be putting up more webinars on YouTube and on our website. Please feel free to reach out to me. You can call me at 408-371-6000. You can email info@sowardslawfirm.com. And we'll schedule a time. If you want to come into the office, I love face-to-face meetings, but if it's more convenient for us to do a go-to-meeting or a webinar or just a conference call, I'm happy to do that for your family. I know people in Silicon Valley that work hard. You don't have a lot of free time. Now, my main office is in Campbell, but like I mentioned, we have satellite offices throughout the state. We're frequently in Palo Alto and Mountain View. Every other Friday we're there. And then we're also opening an office in Santa Cruz, in the Santa Cruz area. So I'd like you to come by and come see me or call me to plan, and we will make sure that your family gets what they need and that you will get the peace of mind. Some of our office locations, places for you to come see me and make sure we do what you need for your family. So hopefully this presentation was useful for you. Hopefully you learned something, and I look forward to working with you. Thanks for tuning in. Bye now.